number 88, People v. Luis Jimenez.
Good afternoon, Your Honors. May it please the Court, my name is Stephen Burko, and I represent Appellant Luis Jimenez on behalf of the Legal Aid Society.
So, counsel, just to be clear, what are the two evils that the defendant was choosing between?
I'd like to answer the Court's question, but I would also like to reserve 2 minutes for rebuttal time.
sorry.
Bingo. Good job, Mr. Burko. You have
That's
2
okay.
minutes for rebuttal.
I
Well,
apologize.
according to Judge Zoll in his June 18th order, the two evils were my client was being restrained by Jonathan's uncle, who was trying to take a broomstick away from my client. And at that moment, the dog approached my client, and according to my client's testimony in front of the grand jury, he was trying to bite my client's leg.
Okay, I'm sorry. So again, what are the two evils? The
two
injury
evils,
to
according-
himself versus,
According to Judge Zoll, the way Judge Zoll saw it in his June 18th order, there was a fight between my client and Jonathan's uncle. Jonathan's uncle was restraining my client and trying to grab my client's broomstick, which he had picked up to defend himself against Jonathan, who had threatened to kill him over the non-payment of a $20 debt. So that was one evil. At that moment, the dog approached my client and was trying to bite him on the ankle.
So did he mistakenly or intentionally hit the dog?
Well, Your Honor,
Does it matter if it was intentional or a mistake?
in effect, the answer to that question doesn't really matter because it's an objective standard under Section 35052. My client's state of mind in whether he was actually trying to hit the dog or whether it was a mistake, it simply doesn't bear on the question before the bar.
Yeah, but when your client is saying different things at different times throughout his grand jury testimony, doesn't that bear on the reasonableness of what he's saying? And aren't the people required in their sort of gatekeeping function to determine what's reasonable and determine whether or not the testimony would lead to a justification charge? Aren't they required to, under the statute, do that?
No, they're not. Under the statute obligates them to decide, was there an altercation? Did a dog approach my client? And did the dog try and bite my client? Those are the only threshold questions that are...
Well, is there a reasonable view of the evidence that supports a justification charge?
That's exactly right. Beyond those questions, they are getting into the province of the grand jury.
Right, so I'm just saying when the defendant, even hypothetically speaking, gives you different versions of it, right, and the testimony sort of evolves, isn't it the people's function to then make a determination if the evidence has risen to this level of giving a justification charge?
Not according to the law of justification that's come down from this court. This court has said in Butt, 72 New York 2nd at 750, that inconsistency in claim defenses, or even between a defendant's testimony and a defense, should not deprive a defendant of the charge if the charge would otherwise be warranted by the evidence.
Correct. That's the second part of it is what I'm concerned with.
Well, those questions then become questions for the grand jury. Those are fact-finding questions. Maybe they would not have credited the defense, but that's a different question than the question of whether he was entitled to the charge on the defense.
but this is where I'm losing you. But it seems his testimony many times over is, it was reflective, it was not intended, I didn't want to hurt the dog, I'm just afraid there's a lot of people coming at me, and I swung.
Well,
Isn't that the reading of the testimony?
that is one reading of the testimony, but the fact that he's not afraid...
What's the other reading? I'm just having difficulty.
He did say the dog was trying to bite him.
Yes,
And
I get that.
He did
And
also
He actually says at several points he was biting him, but he does make very clear, I think over and over, that he was not intending to hit the dog with the stick, that it's pulling back, Right?
But
It's a
again, Your Honor,
reaction, he says several times, it's a reaction.
it's an objective standard, and the fact that he states he's not afraid.
I mean, you know much more about this than I do, but I thought that justification had both a subjective and an objective component to it.
That is true. Justification does have those components under a different subsection of 35. This court said in Craig, talking about the section that's at issue here, there's no reference in section 35052 to what the actor intends or believes to be necessary. In this respect, this section is unlike penal law section 3515, which bases justification for the use of physical force on the actor's reasonable belief that such force is necessary to defend himself or a third person, and for the use of deadly force, again, on the actor's reasonable belief that the other person is using or about to use deadly force. So this court has already parsed out an actor's state of mind in invoking that defense. And I would just like to state, my client...
I'm sorry, I just can't, I'm not satisfied with these answers. I'm just going to be straight with you. I don't understand what the argument is as to the evil that's being avoided and the evil that's being chosen to be done. Because it seems to me his testimony is, this is an accident. I didn't mean to hurt this dog.
Right, but that, I mean,
That's
again,
why it's called choice of evils. You're making a choice.
getting back to Judge Zoll's June 18th order, Judge Zoll saw the two evils as one, the ongoing fight between the uncle and my client, where the uncle was trying to take a weapon from my
So
client.
what's the evil in that I might get hurt?
The evil in that is, yes, the uncle might have been saying to my client, I mean, the video surveillance has no video, I'm going to take this broomstick away from you and wrap it around your head. I mean, that's an evil.
Okay.
Sustaining an injury from the uncle is an evil.
Okay.
And another evil
Does he
is...
state in the grand jury that he feared the uncle was going to harm him?
Yes, he did. In our, I believe it's on page 56 of the supplemental appendix.
So when he was talking about tussling, so you're saying it wasn't tussling, it was fighting, the uncle was fighting him?
Well, he was saying, in my client's words, tussling, I think, is commonly understood as fighting. The uncle was trying to deprive my client of the weapon that he had taken to defend himself against a man who threatened to kill him.
Or for the two to engage in fighting?
Excuse
That
me?
he was preventing one combatant from engaging with another.
Well, that is a construction that the people would submit to this court, but I would say that construction violates the basic principle that in evaluating whether my client was entitled to the charge, you have to construct the evidence in a light most favorable to him. So in that light, the uncle wasn't trying to stop the fight, but the uncle was enraged that he didn't pay $20 to his nephew and was trying to take the stick away
So
from him.
what's the other evil, though? I'm
Can I
still
ask a
trying to get that
question
second
here?
evil.
Counsel, let's just go back to Judge Rivera's question. The choice of evil. So if this person the person is attacking your client, the choice of evil is I can hit that person or I'm going to get harmed. If the dog is attacking your client, the choice of evil is I can strike the dog or I'm going to get bitten.
Right.
Which is it here? It seems to me this is a combination of the argument is the uncle is coming at me, I swing because I don't want to get hurt or he's trying to take the stick away from me, and I accidentally hit the dog. Isn't that an intent argument, not a justification argument?
But no, not under section 35052. His state of mind is simply not relevant. The relevant question really is, was the dog trying to bite him? He doesn't necessarily have to fear the dog's bite in order not to want to endure it.
Then it's the dog. It's the choice of evil is the dog is going to harm me and I hit the dog. That's the support you need in the record.
You could look at it that way, yes.
And that's the problem, counsel, because I don't understand your hypothetical about, or your alternate version of what you can see in the video and what was said at the grand jury, is that the uncle said, I'm going to wrap this stick around your head, which would justify or potentially warrant a justification defense as to some act against the uncle, but how does that provide a justification defense for the dog?
Well, Your Honor, you could look at it together, the way Judge Zoll did it, or you could look at it the way Judge Garcia poses it, that the dog was trying to bite my client at that moment, and he swung the stick. My client doesn't need to be afraid of the dog, not to want to endure a bite from the dog.
But that's not what he said about the dog. What he said about the dog was simply, I didn't mean to do it.
Right, but his intent is not a factor in...
I get that his intent is not a factor, but we're sifting through the record for some reasonable view of it that would warrant giving this defense.
He could have intended to swing the stick just to move the dog away, to scare the dog, and have accidentally hit it. That would be
But that's
consistent.
not what the statute requires, right? He has to be in imminent fear of a grave injury.
It's not a question of imminent fear. He doesn't actually have to stand there and be afraid of the injury. He just has to have cognizance that he may get bitten, which he did.
But this is the problem. The statute said that conduct is
He did it.
necessary as an emergency measure. So if it's only about the dog, it's very hard for me to see that as, given the size of this dog, given actually what you view as an emergency measure, necessary as an emergency measure.
Well,
That's my
well-
problem. However, you're correct. The Supreme Court did view this as this melee, right? That it's the uncle. He actually, the defendant does talk about other people there. He's afraid of other people. He's alone, all of that. That strikes me as different. That's why the questioning about what are the two evils, it sounds to me like you've taken the position, I just want to be clear, that the evil is to hit the dog.
Well,
Opposed to, I'm just throwing my arm around with this stick to protect myself or to retain the stick, the broomstick, that Jonathan is trying, excuse me, not Jonathan, the uncle is trying to take from me, and I want it to protect myself, and oh my goodness, the dog is hit in that process. I understand you think the intent doesn't matter. I just want to know what the challenge is.
I mean, I think I'm going to try and respond to that, and just say that Judge Zoll contextualized this thing, contextualized the act of swinging the stick within the larger context of an ongoing fight where my client was approached and threatened with death for non-payment of a $20 debt. He was being restrained by the uncle. He couldn't move away. In his conception of it, in his testimony to the grand jury, the uncle was trying to take the stick away from him. At that moment, the dog approached him. So Judge Zoll saw these two things as evils. So but the essential question before the court is here, I mean, the nub of the issue is who gets to find the facts? Is it the prosecutor presenting the case to the grand jury, or is it the grand jurors themselves? I would point out to the court that the grand jurors, when they were hearing this case, they asked questions to the prosecutor, such as, was the dog on the leash? Did appellant hit the dog before or during the fight? Was appellant trying to break free? Well, they weren't using appellant, but was appellant actually trying to hit the dog, and whether the dog was menacing my client? Those questions go to show that the grand jurors were evaluating the testimony, as they should have if they had been properly charged, from the perspective of the defendant.
But after his testimony, they're also asking, given his statements that he felt afraid and he was alone in this moment, and he keeps telling the prosecutor, show the video, and they're doing it not quite frame by frame, but they've slowed it all down. They're also asking, did the people come and attack you afterwards? What happened once this dog got hit? You walked away, no one followed you, right? There's certainly these other sets of questions that perhaps undermine the argument about the grand jury potentially having concerns that suggest that the instruction might have led them to a different outcome.
Well, there I would respectfully disagree with Your Honor. The fact that he got away after the incident doesn't mean that he didn't fear the family at that point, and he had no knowledge, he had no foresight of what the family would do after the dog got hit. So I don't think that really bears it out. And the standard to determine whether the charge was proper or not is to construct the evidence in the light most favorable to the defense. That standard wasn't adhered to, and in fact, the entire argument presented by the people here constructs the evidence in the light most favorable to themselves. So they're invoking an improper standard, and under this court's justification law, as long as there's any reasonable line of inferences that would support the defense, it must be given. That wasn't true here. The grand jurors had no legal framework upon which to issue a no true bill. They had no instruction about the law of justification.
Thank you, Mr. Burko.
Thank you, Your Honor.
One moment. Okay. Good afternoon. May it please the court. Assistant District Attorney Charlie Pollack for the people on behalf of Queens District Attorney Melinda Katz.
Sir, just as I was dogged with him, I'm dogged with you here, if you don't mind the pun. What are the two evils that the defendant is choosing between?
Well, that's just it, Your Honor. I think that, as Your Honor pointed out, nowhere in the record does the defendant actually say, or anyone else support, that he struck the dog because he was concerned about a bite from the dog, or to stop a bite from the dog. So in their briefs, defendant is suggesting that it was necessary to strike the dog to stop a bite, but actually that's not reflected in the evidence before the grand jury. To the extent that he claims that there's an evil threatened by the family against him, Craig, the case we were discussing earlier, specifically says that the evil you're choosing has to be reasonably calculated to prevent the harm that's being threatened. And in this case, as Your Honor pointed out, striking the dog would not prevent in any reasonable way whatever harm he fears from the family. Now, on the other side, the evil that he's committing is very serious. He's struck a dog, a tiny 8.4-pound dog, in the face, fracturing its cheekbone, blinding it in one eye.
Let me ask you this. It really does seem to turn from what you're saying on the characteristics of the dog. Because let's say this was a much larger dog, a 100-pound dog, who was quite aggressive. The jaw line is at the thigh, not merely able at the ankles, potentially able to lunge. If that was the dog in this melee, you would perhaps have seen his view of this, no?
I think so, Your Honor. It's a very fact and circumstance dependent analysis. In fact, that's baked into the
Because in that way, you
decision.
could see potentially, it might not, the grand jury might not agree. This is not about whether or not they agree or not. This is
Yes.
whether or not to give the instruction. There you might say, well, in that case, certainly the record might support an argument that it was necessary to strike at that kind of an animal to prevent this, not only an attack from the animal, that's kind of very obvious in this example, but in this melee to help him, right? Because the dog is a distraction. One could view this as, even this little dog is a distraction. It's pulling at his leg, it's trying to bite his leg, and so he's fearful that that will somehow put him in a worse position to defend himself against the uncle.
The fact of the dog is a distraction does not appear anywhere in the record. But certainly I can imagine a situation where, to take your example, a much larger dog or a much more frail defendant, you know, if we're talking about a 90-pound Rottweiler and a toddler, swing away, right? We're not going to be standing here anymore because that's not a case that people are going to prosecute. But because the size of the dog was so small, and because, as we know from our amicus brief, that smaller dogs have smaller bite force and female dogs have smaller bite force than male dogs.
Walk cautiously on that one, but go ahead.
I'm strictly limiting that comment to dog
understand.
bite force. I think that there really is no reasonable view of this evidence, objectively or subjectively, that he was justified in.
If he said, I was afraid of the dog, would that be enough?
No, because
No, because of the dog itself.
there's an objective and a subjective component to this, arguably. Now, I know defendant says that there is no subjective component to 35052. Craig actually has a footnote specifically carving out this situation, saying it is not reaching the question where the defendant subjectively does not intend to commit this harm to prevent it, but objectively, someone could dream up a way where it was reasonable. That hasn't been decided. So Craig was saying that it is an objective standard as opposed to a purely subjective standard, but I think it's open for this court to determine whether or not there should also be a subjective component.
To go back to the reasonableness and the larger dog, that would seem to speak to providing a basis for the justification because larger dog is more threatening, it has a greater bite force, and, one could reasonably understand why hitting the dog is a potentially valid choice under those circumstances. But what we heard from your adversary on argument is that this situation was more broadly contextualized by the court, that this was an effort, a melee was going on, and he was just sort of trying to protect himself from any harm that might be coming his way, which provides, at least I heard it to be, one basis for the argument for why the charge was justified here. Is that permitted under the statute? Can you have this broadly contextualized situation where you're just swinging because you don't want to get hurt? It doesn't really matter what you're swinging at.
No. I think, again, very fact and circumstance specific. But I think that on some level, if you're just wildly swinging around and you accidentally hit a dog, we know that mistakes are not choices of evil. A mistake is not a choice of evil. That's what Rodriguez says.
Well, he may have intended to hit the dog, he may not have intended to hit the dog, but he was just trying to protect himself in the course of, I think I heard the word melee said up here at one point. He's just swinging.
Your honors have seen the video. I think a melee is a very strong word for what's occurring.
No, but on a hypothetical, let's say the video showed, not this case, but big guy coming at the defendant here, he swings the stick to defend himself, choice of evils, but he hits the dog.
He swings the stick to
Swings the
defend
stick.
himself against the person and
Hits the
accidentally
dog.
hits the dog.
Yes.
You're talking about transferred intent
Right.
in a justification defense under a different section of 35. We specifically don't have that here as well either, by the way. He doesn't say he was trying to hit the uncle and accidentally hit the dog. He says he was trying to pull the stick away from the uncle, was trying to get it from him, and accidentally hit the dog. But in that case, I think then you're actually analyzing it under 3515. Because that's an attempted justified self-defense act against the person as opposed to a dog. Then you do have a subjective and an objective component. You also have a proportionality requirement.
So even though the dog is what gets injured in this hypothetical, you think it still fits under because it's an attempt to defend against another, even though that's not who you actually end up injuring?
I think so. I mean, actually, I haven't done the research that far out into 3515. I'm just off the top of my head
You
here.
may hear differently when you get back to your office. Who knows?
I mean, it just, I might. It just strikes me that in that particular case, it would be someone attempting to attack a person who's attempting to attack them. And if they accidentally hurt a dog as well, I think there's an argument it's under 3515. Yeah.
Well, then why isn't that the choice of evils? I'm actually trying to protect myself against them. That's the conduct. But the consequences are against an animal, not an individual. Why isn't that like, what is it, Mayor? Mayor, where you're driving away, you think someone has a gun, right? You think, or a weapon, and they're going to be injured. You drive recklessly. So the conduct is the reckless conduct. You never intend to hit somebody, but unfortunately, that's what happened, right? They killed somebody. Why isn't it closer to that?
Because there's no evidence in the record that he was attempting to strike the uncle. So in this case, there's literally nothing in the record that says he's attempting to hurt another person, or, in this case,
But no, protecting himself from being injured by another person.
he's not
Or
even...
trying to keep the weapon that he's chosen by breaking off this broomstick in half, right? To protect himself against the family. He kept talking about the family.
I think we're outside the realm of justification at that point,
Okay.
Your Honor. It's an argument about intent, which was squarely before the grand jury and roundly rejected by them. So under a subjective analysis, he testifies repeatedly that he hit the dog by mistake. He never says he hit it on purpose to stop it from biting him. Under an objective analysis, the weight of the harm that he did to this dog is an evil that does not was not clearly outweighed by the small amount of harm, the de minimis harm really, that he could have expected from the dog. And as such, there is really no reasonable jury, even viewing the facts in the light most favorable to the defendant, could ever have found the choice of evil's justification appropriate here. And for that reason, this court should affirm the appellate division.
So let me just ask you then, that we could more narrowly, is that what you're suggesting, decide it and saying it's just the injury, let's stay with dog bite for the moment, is not grave enough to justify this knock on the dog?
The risk,
Just deciding it on that ground. Would that be possible?
yeah, I think you
Put
could
aside
look,
every other element of this justification defense, just that one.
in the event that your honors found that looking at the record, there was enough you could slice and dice and
Yeah.
put together to find that he intentionally hit the dog to stop the dog from biting him. Even then, it was a disproportional response by miles. And in that case, the evil he was trying to prevent, the very de minimis threat of a bite through blue jeans from this very small dog, did not clearly outweigh the harm that he caused, the evil that he chose, which was to strike this dog so hard that he blinded it and broke its face.
Thank you.
I just have several quick points, Your Honor, but I'll start with my adversary's, your last question, Judge, and my adversary's last response. The people here are asking this court to find the facts that should have been found by the grand jury. These questions, these factual questions, basically the answers to them depend upon value judgments based upon the moral standards of the community, as Judge Hines Radix said in her appellate division dissent.
Let's say we agree with you that it was error not to instruct. Is this error with respect to the grand jury subject to harmless error analysis?
Well, no, it isn't. If you agree with me, then you would reverse the appellate division's decision, and Judge Zoll's June 18th order would be reinstated, and that order allowed the people to represent to another grand jury. So it's not like they're out of business. They just have to present the same case with a properly charged grand jury. I would also like to speak for a moment about the question of small dog or large dog. A small dog does have canine teeth that are designed to puncture and tear flesh. They've evolved the same way as a large dog. The question as to whether a man should subject himself to the bite of even a small dog, that's precisely the value judgment that goes to the grand jury. As to the question of the...
But this particular justification provision is intended to be used in rare circumstances, right?
Well, I mean, I would say that, you know, I've been practicing law with the Legal Aid Society for 32 years. I've never come across a case like this where a man was being held and threatened, had just been threatened by another man with death, and one of the other man's family members is holding him while the dog is approaching him and trying to bite him. I mean, that's a pretty unique circumstance. I also don't think you could dismiss out of hand the threat of a zoonotic infection. Yes, it's true, it's a small risk. However, someone wins the lottery every week, and it would be cold comfort to my client lying on his deathbed if someone had told him, well, you know, the chances of you dying of this disease that the dog gave you was infinitesimally small, but your estate does have a cause of action for wrongful
He did
death.
testify his own dog had bitten him, and he had two.
Excuse me?
He did testify his own dog had bitten him, one which was a much larger dog, and one that was a Yorkie, and the Yorkie's not the one that bit him, so he certainly is, he has experienced the dog bites in the past. But what about this question of maybe this is really the wrong section of these justification defense provisions?
Well, I think...
This really doesn't fit here because he says time and time again, I wasn't trying to hit the dog. It's not my intention. That was a mistake. I was doing something else.
I think the way Judge Zoll looked at it, that was the ultimate act. I mean, he didn't hit, there would have been a completely different argument here if, as they were tussling for the stick, my client poked the uncle in the eye with it.
Sure.
And that would have ended the fight. So, looking at it in that context, is it better to hit the dog, although you cause regrettable injury to the dog, or hit the man?
But Mr. Burkle, am I mistaken about this? Didn't he testify that he was struggling with the uncle so that he could go after Jonathan?
I don't
Who
recall
was
that.
walking away?
Well, I mean, again, as this court found in its cases discussing the entitlement to the justification charge, inconsistency in testimony doesn't deprive you of the charge. As long as there is one rational line of inferences that support the charge, then you're entitled to it, even if you say something that contradicts the charge.
Maybe this is just too linguistically simple, but I'm having a little trouble applying a choice of evils defense to a defendant who says, I didn't make a choice, this just happened accidentally.
Again, I would go back to this court's decision in Craig and remind Your Honor that it is not what is in his mind as opposed to it is the objective reality of what's going on. Objectively speaking, the dog poses some threat of a viral or bacterial infection. It's some threat more than nothing.
But counsel, Craig calls for an imminent threat and a reaction to that imminent threat. A viral infection doesn't sound very imminent.
Well, I mean, if it's something more than nothing, which is what the people concede, then if he's bitten, there's also the question of whether he has to endure a bite. I mean, that's another value judgment that Judge Heinz Radix would have assigned to
He also has to buy
the...
a new pair of jeans because the dog put a hole in them, but the question is
Right.
whether it rises to the level of justifying the force that was used.
I agree with Your Honor. That is the question, and that question was for the grand jury and not for the prosecutor. The only way that the prosecutor could have deprived the grand jury of the defense within the context of the standards that we've discussed here is if the animal at his ankle posed absolutely no chance of harm to him, such as a pet butterfly, if it were that he cruelly crushed. But let's say the companion animal here wasn't a dog, but a highly trained rat. Those are very intelligent creatures. I mean, would the court say, because it's small and has a little biting power, that he's not entitled to swing a stick at a rat that's nibbling at his ankle? I mean, to base the rule upon an exception to the rule upon the size of the dog, I think opens up put it this way, I think it greatly infringes upon the grand jury's fact-finding abilities.
So if it was just a toddler, you could hit the toddler with a stick?
No, that's not what I said. There has to be a threat posed.
They do carry some diseases, toddlers.
Well, I had a couple of my own. I know that's true.
Thank you, counsel.
Thank you very much, Your Honors.